Petitioner Larry SCHAFER petitions from a Court of Appeals decision. The Court of Appeals affirmed the judgment entered on a jury verdict in favor of Shirley HOFFMAN in the amount of $715,000. We affirm. On January 15, 1988, SCHAFER struck HOFFMAN, a pedestrian, with his vehicle. SCHAFER was under the influence of alcohol and drugs at the time of the collision. As a result of the collision, HOFFMAN sustained numerous injuries, including a compression fracture in a spinal vertebrae and concussion with intracranial bleeding, a fractured femur in her left leg, and torn cartilage in her left knee. HOFFMAN also sustained other injuries to her left leg, left hand, and right elbow. HOFFMAN filed an action against SCHAFER, which proceeded to trial on January 3, 1989. SCHAFER admitted negligence in the operation of his vehicle, but denied that his conduct was willful and wanton, and disputed the nature and extent of HOFFMAN's injuries. SCHAFER contended that HOFFMAN had pre-existing injuries for which he was not liable because they were not caused by his conduct. HOFFMAN produced numerous witnesses at trial, including Dr. Roop, her orthopedic surgeon. Dr. Roop testified that he treated HOFFMAN shortly after the January 15, 1988 accident. Dr. Roop was aware that HOFFMAN had developed thrombophlebitis in her left leg around her knee as a result of the accident. HOFFMAN took anticoagulant drugs in order to reduce clotting. As a result, Dr. Roop could not perform surgery on HOFFMAN's knee until the clotting had sufficiently dissipated. Dr. Roop referred HOFFMAN to a physical therapist, but determined early in the fall of 1988 that surgery was necessary based on the lack of improvement in her condition through the course of her therapy. On cross-examination, SCHAFER elicited testimony that Dr. Roop had treated HOFFMAN 2 months prior to the accident, in November 1987, for pain in her right knee. She could not fully extend her knee at the time and was taking Motrin, a drug designed to decrease swelling of arthritic joints, on an as-needed basis. Dr. Roop prescribed Darvocet, a mild painkiller, and Chloranol, an anti-inflammatory drug, during November 1987. In summary, the jury heard evidence introduced by SCHAFER that HOFFMAN had complained of knee pain and lower back problems prior to the accident, and that the vertebrae fracture might have occurred prior to the January 15, 1988 accident. The jury also was aware that HOFFMAN's knee had some degeneration as a result of the normal aging process, that HOFFMAN might be predisposed to causalgia, and that HOFFMAN's knee surgery was delayed longer than the average person's because of her blood clotting condition. At the close of the trial, HOFFMAN submitted a thin skull instruction which read as follows: in determining the amount of plaintiff's actual damages in each of the various categories set forth in instruction number 16, you may not refuse to award nor reduce the amount of any such damages because of any physical frailties of the plaintiff that may have made her more susceptible to injury, disability, or impairment. SCHAFER objected to the giving of this instruction on the grounds that the instruction told the jury that they may not refuse or reduce the amount of damages because of HOFFMAN's pre-existing physical ailments. SCHAFER contended that there was no evidence of aggravation of HOFFMAN's condition, and thus SCHAFER could not be held liable for her pre-existing conditions. The district court, however, gave the challenged instruction to the jury. The jury found for HOFFMAN, and SCHAFER appealed. The Court of Appeals concluded that the instruction was a proper statement of the law and that it was supported by the evidence in this case. SCHAFER petitions this court for a determination that the thin skull instruction is not a correct statement of law and that the Court of Appeals erred in holding that HOFFMAN was entitled to the instruction as her theory of the case. We disagree. The term thin skull or eggshell skull is derived from illustrations appearing in English cases where a plaintiff with an eggshell skull suffers death as a result of a defendant's negligence, where a normal person would only suffer a bump on the head. Delu versus White and Sons. W. Page Keaton et al. Prosser and Keaton on the Law of Torts. The negligent defendant is liable for the resulting harm even though the harm is increased by the particular plaintiff's condition at the time of the negligent conduct. A negligent actor must bear the risk that his liability will be increased by reason of the actual physical condition of the other toward whom his act is negligent. As Prosser notes, there is almost universal agreement on this rule. Prosser 43 at 291. There is almost universal agreement upon liability beyond the risk for quite unforeseeable consequences when they follow an impact upon the person of the plaintiff. Liability beyond the risk, however, is not solely premised on the existence of ascertainable pre-existing physical conditions. The defendant is held liable when the defendant's negligence operates upon a concealed physical condition, such as pregnancy or latent disease or susceptibility to disease, to produce consequences which the defendant could not reasonably anticipate. The defendant is held liable for unusual results of personal injuries which are regarded as unforeseeable, such as tuberculosis, paralysis, pneumonia, heart or kidney disease, blood poisoning, cancer, or the loss of hair from fright. Prosser 43. Some scholars have interpreted the thin skull doctrine to encompass the plaintiff's physical, mental, or financial condition. Fowler, Harper et al., The Law of Torts. And these pre-existing conditions may have the greatest bearing on the extent of the injury actually suffered by any particular plaintiff in a given case. Thus, the same slight blow in the abdomen might cause only fleeting discomfort to a man, but a miscarriage to a pregnant woman. Under Colorado law, it is fundamental that a tortfeasor must accept his or her victim as the victim is found. Stephen and Kraftco Corp. versus Koch, 129, Colorado, 531533. As this court has made clear, a defendant must take his victim as he finds him. Under the common law principles of tort law, it is axiomatic that the tortfeasor must accept the plaintiff as he finds him. Accordingly, under the thin skull doctrine, a tortfeasor may not seek to reduce the amount of damages owed to the victim by spotlighting the physical frailties of the injured party at the time the torturous force was applied to him. A thin skull instruction is appropriately given when the defendant seeks to avoid liability by asserting that the victim's injuries would have been less severe had the victim been an average person. Holding that the defendant could not escape liability where plaintiff had a prior fragile condition making her more susceptible to certain injuries than the average person. The thin skull doctrine has not been limited to pre-existing bodily conditions. See Prosser 43. The doctrine appropriately applies where a plaintiff may be predisposed or more susceptible to ill effects than a normal person. See City of Scottsdale versus Kokoska, 17, Arizona. Plaintiff had no pre-existing injury but rather an anatomically different spine. Walton versus William, Wolf Baking Company. holding that tortfeasor was required to take plaintiff as found with predisposition to neurosis. Reck versus Stevens, plaintiff had an underlying emotional instability. Freymeier versus Lufty, the established rule is that where the result of an accident is to activate a dormant or incipient disease, or one to which the person is predisposed, the negligence which caused the accident is the proximate cause of disability. The challenged instruction encapsulates the fundamental thin skull doctrine. A party is entitled to an instruction embodying his theory of the case if there is evidence in the record to support it. Newberry versus Vogel. During trial, SCHAFER attempted to establish that Hoffman had long-standing complaints with regard to her knees. SCHAFER sought to prove that Hoffman's recovery process was longer than the average person's because arthroscopic surgery expedites recovery, but was delayed in Hoffman's case as a result of her blood clotting condition. SCHAFER also attempted to establish that chondromalacia can develop over the course of the normal aging process. SCHAFER elicited through cross-examination of Hoffman's physical therapist that Hoffman had some degeneration in her knee as a result of her age. The testimony elicited by SCHAFER in this case could lead the jury to believe that Hoffman suffered frailties or was more susceptible to certain medical infirmities than the average person. The challenged instruction merely informed the jury that SCHAFER could not escape liability because of Hoffman's condition at the time of the accident. The trial court did not err by giving the thin skull instruction to this case. SCHAFER contends that the Court of Appeals erred in holding that Hoffman was entitled to a thin skull instruction as her theory of the case. SCHAFER specifically argues that the Court of Appeals determination was based on Miss Woodward's testimony and that her testimony supported analysis of true value issues and not the thin skull instruction. We disagree. The true value of or shabby millionaire rule complements the thin skull doctrine. Gary Barr versus Bruce Graham. The thin skull doctrine declares that foreseeability of plaintiff's injuries is not an issue in determining the extent of injuries suffered, while the true value or shabby millionaire rule declares that foreseeability is not an issue in determining the extent of damages that the injuries cause. The Court of Appeals discussed the testimony of the orthopedic surgeon regarding Hoffman's particular condition at the time of the accident. In the context of this discussion, the Court of Appeals noted that Miss Woodward, a vocational rehabilitation counselor, testified that Hoffman would be disadvantaged in the job market. The record amply supports the Court of Appeals' determination that the thin skull instruction was proper in this case. We thus find SCHAFER's contention to be without merit and affirm the judgment of the Court of Appeals.